First up, we have Lady Justice Wolayo Henrietta. Lady Justice is a distinguished Ugandan jurist and dispute resolution practitioner with over 40 years of experience in judicial adjudication, dispute resolution, and justice sector leadership. She served as a judge of the High Court of Uganda for 12 years and most recently as senior resident judge in Luwero, after holding several senior judicial positions as a High Court judge. Lady Justice Wolayo is currently serving as the Regional Director representing East and Southern Africa on the board of the International Association of Women Judges. Welcome, Lady Justice. Next up, we have Olga Boltenko. Olga is a barrister and arbitrator and mediator with over a decade of experience in cross-border dispute resolution and international arbitration. Most recently with Fangda Partners in Hong Kong, Olga has also practiced with leading arbitration teams in Paris and Singapore. Olga teaches a Master's of Law degree in arbitration and ADR with a focus on Belt and Road Investment Law at the University of Hong Kong, where she is a Deputy Executive Director. She's also a professor of law at the Royal University of Law and Economics in Cambodia, where she teaches a course in investment law, at the dual degree program with the Free University of Brussels. Last but definitely not least, we have Saisen Hu, who is a counsel with HKIAC. She predominantly operates in the arbitration team of Hong Kong International Arbitration Center. She administers cases in English and in Chinese and acts as a tribunal secretary in HKIAC and ad hoc arbitrations. Between 2022 and 2024, CN served as a committee member of HKIAC 45, a young practitioner group established under the auspice of HKIAC. Prior to joining HKIAC, Saisen interned as international law firms in Paris and London, where she was involved in commercial and investment arbitration cases. She also interned at the International Tribunal for the Law of the Sea in Hamburg. Saisen is fluent in Mandarin, English, and French. Please allow me to welcome each and every one of you. And I really look forward to the discussion that we are going to have this afternoon. So to set us on course and to establish context for our discussion, perhaps I can commence with you, Lady Justice Henrietta, and ask, arbitration has become more complex over the years. What specific changes have made tribunal secretaries more essential today than they had been before?
Thank you so much, Wambui, for that kind introduction. Now, I come from a judicial background, so in this webinar, I'll draw extensively from my experience at the bench. The current tribunal secretary previously performed clerical work and perhaps was not even a lawyer. Similarly, clerks supported judges with registration of cases, organizing files, fixtures, recording the sittings in a chronological order, among other tasks. Now judges have judicial assistants or research officers to support them in the judicial function. The role of a tribunal secretary has a more legal-oriented role aligned to the arbitral process. Just like in the judiciary, this has been prompted by a number of factors. Now, some of these factors include the increased case complexity and volume of evidence, especially in international arbitrations that call for their dedicated support to manage these files, as the tribunal is focused on the substantive aspects of the case and decision-making. Another factor is the pressure for efficiency on tribunals amid the increased workload. Parties want their cases to be heard faster and efficiently in a cost-effective manner. So having a secretary allows the tribunal to focus on the decision-making of the case, while the secretary handles the administration. Another factor is the very specialized nature of the cases that are coming up. For example, those involving Bitcoin and AI issues. Tribunals benefit from expert secretaries who bridge the technical gaps in these areas. And lastly, recognition of the important role of secretaries in the arbitral process. The fact that these secretaries are recognized by arbitral institutions with dedicated guidelines underscores the important role they play in the arbitral process. And some of these arbitral institutions that have guidelines dedicated to secretaries include the International Center for Dispute Resolution and Hong Kong International Arbitration Center. Thank you, moderator.
Thank you so much, Lady Justice. And I think you've touched on a very important point. I think the cruciality of a tribunal secretary is apparent, but I think something that people are concerned about is how do you bring in secretariats to the arbitral proceedings without necessarily increasing cost? And perhaps I can ask Saisen, from an institutional perspective, how do tribunal secretaries improve procedural efficiency without increasing cost? Because that's always a factor for the parties and a consideration. Thank you.
Thank you, Monbei, for the kind introduction, and thank you for the question. First I want to share some slides. Just want to check, can everyone see my slides?
Yep, your slides are clear.
Yeah. So first of all, I'd like to highlight that the HKIAC, we launched the Tribunal Secretary Service in 2014. So we were the first arbitral institution to do so. And in the same year, we also issued the HKIAC guidelines on the use of a secretary to the arbitral tribunal. And Lady Justice already mentioned it. As of today, HKIAC legal staff have received 135 tribunal secretary appointments in HKIAC administered arbitrations and the ad hoc arbitrations. Here are the profiles of our current legal staff. So they're from 8 different nationalities, speak 10 language, have backgrounds in both common law and the civil law system, and have private practice experience at international firms. So now to answer your specific question, based on our 10-year experience, tribunal secretaries help save substantial time and cost in arbitration. So why is that? Tribunal secretaries can take on administrative, organizational translation to certain research and drafting tasks. And as a result, arbitrators can focus their energy on substantive merits of the case. You may know that in HKIAC arbitration, by default, arbitral tribunal charge based on hourly rate. So for instance, if an arbitrator charges, for example, 5,000 Hong Kong dollar per hour, and then for some administrative task, if a tribunal secretary can do it at a much lower hourly rate, and for sure this can help parties save costs. Now I would like to share 2 short videos, a testimonial of one of our legal counsels and also testimonial of the arbitrator.
I'm a counsel with the HKIAC sector.
I just want to check whether people could hear the video sound.
Yeah, we can hear it clearly.
Secretariat. I have acted as a tribunal secretary for 4 sole arbitrators, where my roles and responsibilities have included administrative work, such as liaisoning with the parties, as well as research, paper management, and also non-substantive drafting. I think my role and responsibilities as a counsel at the Secretariat brings a lot to the arbitration, given my familiarity with HKIAC's rules, practices, as well as processes and procedures. And I think overall this really helps in reducing the costs of an arbitration, given that the costs of the more routine administrative work shifts from the higher hourly rate of an arbitrator to the more cost-efficient hourly rate of a tribunal secretary.
The HKIAC tribunal secretaries are an invaluable resource in my work as an independent arbitrator. Their ability speaks well for the critically acclaimed tribunal secretary program organized by the HKIAC. Now, it helps that the experience as case counsel at the HKIAC Secretariat means that they are conversant with HKIAC procedures, but also importantly, the culture of doing things, such as their professionalism, their eagerness to help, and also their responsiveness. Now, a bonus is that many HKIAC tribunal secretaries are bilingual in English and in another language, such as Mandarin, a useful resource in bilingual arbitrations.
So I hope this answers your question.
Yeah, I think it does put it very eloquently for us. I think something that comes up quite often over and above efficiency and cost is the concern that the incorporation of a tribunal secretary equates to the argument of a 4th arbitrator. And perhaps Olga, from counsel's perspective, arbitrator's perspective, you can chime in. Do you think this concern is still valid, or has practice evolved past the 4th arbitrator debate? Thank you, Olga.
Thank you very much, Wambui, for the introduction. Thank you to the audience for taking your time to attend the webinar. And also many thanks to my co-panelists, to Sitzen, but also to Lady Justice Henrietta for gracing us with your presence. This is a very interesting question, Wambui, and it cannot really be answered with a simple yes or no. I would think that the concern is definitely still there. It is perhaps less of a concern in certain cases, in particular where the tribunal secretary role is regulated by the institutional guidelines and controlled by experienced tribunals. It is perhaps more of a concern in other cases where institutional guidelines do not apply in the tribunal. Do not necessarily have the extensive experience of working with the tribunal secretaries to the point that the integrity of the arbitral process is safeguarded. And I think one of the watershed moments in that process of evolution of this concern was the challenge that was brought to one of the largest awards in the history of international arbitration. And that was an award issued under the auspices of the Permanent Court of Arbitration in The Hague, where the challenge was brought on many grounds, but including on the ground that the tribunal secretary, in fact, acted as a 4th arbitrator. And in that particular case, the claimant party also even submitted a forensic expert report analyzing the award and identifying the parts that were actually drafted by the tribunal secretary, and that constituted over 80% of the award. And so the courts at the seat of that arbitration in The Hague had to deal with those arguments, deal with that evidence, and specifically deal with the role of the tribunal secretary. Since then, the role was definitely clarified verified, regulated. And I think for the Chartered Institute of Arbitrators in Kenya, definitely an interesting moment coming up with the Tribunal Secretary training that will be organized with the HKIAC colleagues of Citizen here on the line. And I think with more webinars similar to the one that we have now, with more training programs around the world, including in Kenya, in Hong Kong, and Singapore, that concern will become less and less important.
Thank you so much. And for our audience members, for anybody who's not aware, there is that training. So look out for it, register and attend. Just picking up from where you've left off, Olga, and perhaps I can go back to Saisen and the sentiments you are making about HKIAC. Could you walk us through, perhaps for those who are on the platform and newer to the procedures of what a tribunal secretary does, would you be so kind as to walk us through what a typical week looks like for a tribunal secretary during an active arbitration? And while you're doing so, perhaps you can enlighten us on how, during that process, the tribunal secretaries can maintain impartiality when working very closely with the arbitrators. Let's have your comments. Thank you.
I would say, so 2 questions. First of all, typical week. I would say a tribunal secretary's typical week is defined by unpredictability. Let me try to give you a clearer picture. First of all, most arbitrations run several years. So depending on the stage of arbitrations, your week can look quite different from one phase to the next. Take a substantive hearing, for example. If a hearing is taking place over, let's say, 5 days, you will need to attend a hearing alongside the arbitrators. And during the hearing, your task might include keeping track of time, managing the attendance sheet, organizing files, locating documents on the spot, and taking some notes for the tribunal. And typically 5-day hearing starts at maybe 9 or 10 a.m. local time and finish at 5 p.m. or 6 p.m. local time. On the other hand, if an urgent application comes in, the week looks very different. In that scenario, you may need to summarize the application and then discuss it with the tribunal and help the tribunal draft directions. And then as party file further submission, you will need read those and then help the tribunal draft a relevant decision. So in a nutshell, I don't think there's a typical week as a tribunal secretary, but I guess that variety is exactly what makes the role both challenging and interesting. And in relation to your second question about the impartiality, so that's an excellent question. So a tribunal secretary's impartiality is something that we take very seriously at HKIAC. So let me walk you through under our rules and in practice. So first of all, our current version, 2024 version of HKIAC Administrative Arbitration Rules address this directly. So if you look at the Article 13.4, which states that a tribunal secretary must remain at all times impartial and independent of the parties. Moreover, a tribunal secretary has to disclose any circumstances likely to give rise to justifiable doubts about their impartiality or independence, both before appointment and throughout the arbitration. In addition to the rules, our HKIAC guidelines contain very similar requirements. For instance, paragraph 2.10 provides that the tribunal secretary shall be subject to the same standards of impartiality and independence as the tribunal. So let me explain how this works in practice before and after appointment. Before being appointed, the proposed candidate must sign a declaration confirming their availability to assist the arbitral tribunal, as well as their impartiality and independence. At the same time, they must disclose any circumstances that could raise justifiable doubts. After being appointed, tribunal secretaries have a continuing obligation to disclose. More specifically, they must promptly disclose any new circumstances that give rise to justifiable doubts. So let me give you a concrete example. Suppose you're appointed as a tribunal secretary in one case. Later on, the claimant changes its counsel, and one of the lawyers found that new consultee happens to be the sole arbitrator in another ongoing unrelated matter where you serve as a tribunal secretary. In that situation, you would need to disclose that relationship immediately. Yeah, I hope this answers your two questions. Yeah.
No, that aptly answers my question. And I think it fits very well into what Olga was saying as to the fourth arbitrator's argument. And also I think it's apt that the rules and regulations that he accuses are also synonymous with other major institutions. And so just keeping an arm's length distance from the parties, but also holding the secretariat to the same standard as the arbitrator is crucial. Something that Henrietta had perhaps touched on earlier, and I'd love if you could expound on it a bit more. At which stage, whether it's the pleadings, the hearings, or the award drafting, in your assessment and in your experience, would you say do the tribunal secretaries add the most value, and why?
Thank you, Wambui. Yes, they add value at different stages of the arbitral process. At the appointment stage, they draft the acceptance letter, although the dispatch is done by the arbitrator. Pleadings, at the stage of pleadings, when pleadings are filed, the secretary files them, marks them for easy retrieval, notes the dates when the filing is done, and prepares summaries of the claim and defense. Then at the stage of preliminary hearing, the arbitrator confers with parties on the convenient date for preliminary meeting, but the secretary drafts order for directions number 1, calling for the meeting. And then at the preliminary meeting itself, the secretary documents proceedings of the meeting and drafts order for directions number 2. At hearing stage, the secretary documents or edits transcripts for approval by the arbitrator before being shared with parties if they request for them for copies. And at the stage of award writing, the secretary verifies authorities filed by counsel, details the history of the case, and carries out research under the arbitrator's guidance. So Wambui, before somebody else comes in, can I say something about the fourth arbitrator?
Please,
concern?
share your thoughts. Yes, please.
Okay, yes. Parties fear that the secretaries may draft substantive parts of an award, such as legal reasoning or final analysis, without sufficient scrutiny from the arbitrators. That's why there's this whole thing about, the secretary being a fourth arbitrator. And then another reason they fear is undue influence, that a secretary who drafts the first draft of the award, her perspective, his or her perspective may influence that of the tribunal. So this is, kind of undue influence. There's that fear. And then there's also lack of transparency. They complain about lack of transparency in the appointment process. And lastly, as Shishen has said, the issue of confidentiality and impartiality. They fear that if a secretary is involved in private deliberations, it can compromise the integrity of the tribunal's process. But fortunately, all these fears have been mitigated by the guidelines that have been developed by arbitral institutions and also by the case cited by Olga.
Thank you, Lady Justice. And I agree entirely with your sentiments. I think as we are progressing, something I'd like to get all of your thoughts on is how has that translated, whether in your experience or otherwise, in arbitration proceedings that are ad hoc? Have parties in such an instance had the same success? Seeing that perhaps, yes, those proceedings may be governed by specific rules and regulations that the parties agreed to be applicable to the procedure, but without the oversight that institutions bring, has your experience been that equally works well in those instances? But we'll come back to that. For Olga, if you don't mind me just picking up on something you had said in your last statement, and you can comment on the question I've just asked now. From your experience, what are the 3 top skills that a tribunal secretary should possess, and what differentiates or distincts a good tribunal secretary from an exceptional tribunal secretary? Your thoughts, Olga. Thank you.
One second, I have to. This is a very sort of apt reference to what Sitzen was saying about the unpredictability of the role, because in this particular case with me, my primary laptop malfunctioned, and I had an iPhone prepared just in case that happens, so that I can continue the webinar. And this is, I think, one of the sort of important qualities of the tribunal secretary, given the unpredictability of the process, to be prepared for everything and anything. I know from Sietzen's work, we do work on a couple of cases together, that cases do become rather unpredictable, and that requires the tribunal secretary to be on alert most of the time. And I think that ability to address any procedural or otherwise administrative issues that arise in the arbitration really creates a distinction between a good tribunal secretary and an exceptional tribunal secretary. As to the qualities, it's a very interesting question, Wambui. Thank you very much for that question. I would think that the qualities that are required of a tribunal secretary would differ from the case to case, and also would depend on the tribunal and what the tribunal actually needs. But having acted as a tribunal secretary in a number of cases, I would rate the following 3 qualities as very important ones. First, that should be a stellar substantive and procedural knowledge of the law of arbitration. And that perhaps that may be a controversial quality, because what Her Lady Justice mentioned, and also Sitzen and in the videos from the HKIAC, the tribunal secretary's role is largely confined to administrative role. But in fact, in order to be able to perform and discharge that administrative role correctly, in order to be able not to cross any red lines as a tribunal secretary that might undermine future award, the secretary actually has to have this stellar substantive and procedural knowledge of arbitration, but also in order to be able to assist the tribunals with managing the documentary evidence, with managing the process, with preparing draft procedural orders and otherwise. That is really something that's required. That also is important when it comes to sort of looking for mentors for a tribunal secretary who has no knowledge of international arbitration. The role is likely be that benefits the tribunal secretary more than the arbitral tribunal or the parties, because the secretary will then be learning arbitration as the process develops. But that's, I think, something that we might cover later on in the webinar. The second skill or quality that I find to be very important is emotional intelligence. As you know, the arbitral process in itself is already quite contentious. The emotions run high. The parties argue their cases robustly. Counsel get all worked up over various issues, procedural ambushes, and what have you. You might also have the dynamic within the tribunal that is relatively complex. So as a tribunal secretary who is meant to serve as a channel of communication between the tribunal and the parties, but also to assist the tribunal, for example, during deliberations where the tribunal members may disagree, possessing a relatively high degree of emotional intelligence makes that role really stand out for an experienced tribunal secretary. And finally, I would mention diplomatic skill is also an important role because, in particular, when it comes to the final stages of the arbitration, where the tribunal secretary attends the deliberations and observes the tribunal make up their collective minds on the content of the award, and then perhaps later assists with condensing the tribunal's thoughts on the arbitration into paper. That diplomatic skill is required in order to be able to balance the conflicting views of the arbitrators, for example, or during the hearing when various counsel have various administrative, technical, and otherwise requests of the tribunal secretary who is managing the hearing. The diplomatic skill also comes in as quite handy, in particular when counsel are rushed, have no time, need to have things resolved. So you need to be able to manage those relationships diplomatically. So I think stellar substantive and procedural knowledge, emotional intelligence, and diplomatic skill would be my top three.
Okay, great. And a parting shot on the ad hoc proceedings.
On the ad hoc proceedings, Wambo, I think this is where the role of the tribunal secretary becomes even more important, specifically because there is no control exercised by the arbitral institution that would otherwise administer the proceedings. There, the parties would then have the a person who is able to administratively manage the proceedings, ensure that the proceedings run smoothly, ensure that all the relevant bookings are made for the hearings, for example, that all of the procedural deadlines are entered into the case calendar, that there are all the relevant reminders, and that the integrity of the process is observed. But also, the tribunal secretary would then also be able to manage the case documents, case materials, and particularly if you're working with senior arbitrators who might not necessarily be very used to various artificial intelligence tools or technologically advanced tools then or cloud-based equipment, they might be able to just make sure that the arbitrators always have the entire case file at the top of the fingertips in order to be able to work on the case. So I think that's where the tribunal secretary's role becomes very important. But that's not to say that in institutional administered arbitrations, the tribunal secretary is not necessary. That's not true. Also in administered arbitrations, actually the tribunal secretary, and this is speaking from counsel perspective, gives additional guarantee or assurance to the parties, to counsel, that the arbitrator will be able to discharge his or her functions appropriately.
I think you've even touched on what I wanted to raise next, and that is on technology and AI, and perhaps Saisen can chime in to the conversation. I mean, we hear it time and again, where all of our jobs are going to be replaced by AI. So particularly for tribunal secretaries, how is technology lending itself to the work that the tribunal secretary does? And in your assessment, do you believe that technology and AI can replace the work of a tribunal secretary, make it more efficient, make it more cost effective? Or is there still a prudent role to be played by a natural person in the capacity of tribunal secretary? Saisen, thank you.
Thank you, Wambe, for your question. Personally, I don't think tribunal secretary will be replaced by AI. And just as Olga mentioned, that all the skill set that a tribunal secretary, exceptional tribunal secretary needs to have, I think for the short or long term, maybe it's difficult for AI to have. Of course, like AI is increasingly being used in arbitration these days. So for tribunal secretaries, so at the same time, of course, we are also need to be AI savvy. We learn how to use AI tools, but at the same time, we bear in mind our confidentiality obligations and try to adapt ourselves carefully to the use of AI. Of course, some people may be concerned that many tasks which a tribunal secretary used to take on could be delegated to AI. I think to some extent it's true. I've seen cases where arbitrators use the AI to produce bilingual English and Chinese directions, and that was also disclosed to the parties. And for some research, drafting, or proofreading tasks, I guess AI is indeed able to do similar jobs, and I believe they're doing this now. But just as I mentioned in the beginning, personally, I think with the evolution of arbitration, the tribunal secretary's role has also evolved to take on additional tasks that AI cannot replace. For instance, assisting the tribunals with overall case management, coordinating with different members of the tribunal. So as Olga mentioned, so as a tribunal secretary, you need to be aware of the dynamics among different tribunal members. I think that's something that a human being is more equipped to do so, and also liaising with the arbitral institution. So I think it really pushes us to become more strategic in what we do. Yeah, that's what I want to share.
Thank you, Saisen. I think our audience has a better understanding of what tribunal secretaries do, but I think what they perhaps is a gap in knowledge is how do we become tribunal secretaries? And just before I welcome Olga to give us probably blow by blow on the procedure we should follow, perhaps I can ask Lady Justice Henrietta, in your view and in your experience, the people you've worked with, how important is networking to a tribunal secretary, and how important is mentorship to a tribunal secretary? And somebody starting out today, what steps can they take to get well acquainted with appropriate mentors to walk them through this journey? And when they're going to networking events, who should they be talking to? What should they be saying? What should they be looking out for? What would your guidance be? Thank you.
Well, Wambui, that's a very long question, but I'll try to, to respond based again on my experience as a judge, because I've just entered the arbitration world after retiring just, late last year. So mentorship is very important, because for us as judges actually mentor their research assistants or officers here in Uganda, which is, write awards. We mentor them on research, on how to analyze evidence. So really the secretary is mentored principally by the arbitrator. And then with regards to networking, they definitely have to network, attend all these, conferences, read, go and study, the certificate course for membership to Ciarb, and yeah, and also and join online. Is it what be visible online through LinkedIn, and yes, generally be proactive and be relevant, attend training, etc. Thank you so much.
Thank you. I hear you to be saying, they need to be sharpening their skills, gaining the knowledge that they need to, being under the guidance of a mentor, understanding the procedure, and also putting themselves out there so that they can ultimately test what it is that they have learned and their ultimate skills. Olga, perhaps you can chime into the conversation still on the same topic as to how people can get their foot in the door as regards being a tribunal secretariat. From your experience and the people that you've worked with, what would you say is the best place to start? How do you get your foot in the door and how do you progress?
Thank you, Wambui. That really is a multi-layered question because the answer would depend on the starting point of the person who is seeking to get the first tribunal secretary appointment. For example, if you are already an experienced practitioner, and I see that in the list of attendees there, in-house counsel, heads of legal departments, and other very experienced practitioners, if they're looking to gain that experience as tribunal secretary, perhaps later to be able to build on their arbitrator profile and get arbitrator appointments, then for those practitioners, perhaps the most natural way would be to, in fact, what Lady Justice mentioned, get a certification of a tribunal secretary with a reputable institution, either with the Chartered Institute of Arbitrators or any of the arbitral institutions. And through that certification, typically you would have to attend a course and pass some sort of examination. And through that attendance, you will start building your network with other potential tribunal secretaries, but also with arbitral institutions and with the instructors who are oftentimes the arbitrators themselves. And you can build on that network later on, make it known to the network that you are open to tribunal secretary appointments, get listed as a tribunal secretary on their rosters at the institutions, for example, at the Hong Kong International Arbitration Center. With each iteration of the tribunal secretary program, qualified tribunal secretaries are added to the roster from which they can then be appointed and selected. For those who are younger practitioners, for example, students or practitioners with perhaps less experience in international arbitration, I actually wouldn't, I mean, of course, getting the educational background right and getting visible in the online space would be very important. But also for those, I would think courage is an important quality because there's no harm in reaching out to the arbitrator that you view as a role model and say, well, I'm a student in final year of law studies, I'm majoring in arbitration, I've taken these courses, and I'd like to perhaps shadow you as an arbitrator or offer my tribunal secretary services. And that can be a starting point. And I would even say that it might be discouraging to say that, but some of the most experienced arbitrators in Hong Kong, Neil Kaplan, for example, he would say, "Oh, it all depends on luck, being in the right place at the right time." And I feel that to a certain extent that's right, but also I'm hesitant to give advice based on luck because luck is not something that you can necessarily control. Thus, I would think that luck does find those who are working hard and building their way up to international arbitration. So making it known to the network that you're open to the appointment, getting the relevant certifications, reaching out to the arbitrators, but perhaps even to arbitral institutions, saying that you are willing to take up those appointments would be the way to go, I would think.
Thank you so much, Olga. I want to shift gears to Saisen and perhaps still on the same topic, but perhaps from an institutional point of view. What would your comment be on people who start out as tribunal secretaries and transition into full-blown arbitrators sitting on tribunals? What route would they use and what benefit do they have starting out as a tribunal secretary transitioning into an arbitrator? and what advice would you have for them?
Thank you for your question. And so we do see in HKIAC arbitrations some former tribunal secretaries, and then they act as we appoint them as an arbitrator in some cases. Personally, I think so. If you act regularly as a tribunal secretary in some very sophisticated, high-profile cases, and you do a good job, and you will be seen. And from institution perspective, when we want to appoint some junior arbitrator, because as institution we always want to promote young arbitrator, rising arbitrator who have never been appointed before. We will look at those profiles. So the first step, I guess, because we are not talking about the tribunal secretary. So first step, I think, to try to get a tribunal secretary appointment, and then while you're acting as a tribunal secretary, I work hard, and then you'll be seen, and then I think the transition will be natural. But of course, during this process, I guess it is similar to how you get the first appointment as a tribunal secretary. For example, networking, publishing the articles on your arbitration experience, and try to be listed as a arbitrator at HKIAC or other institutions. Yeah, that's what I have in mind.
Great. We have less than 10 minutes, so I don't want to take too much of our audience's time, but I do want to comment that if you have any questions, please drop them in the comment box below, and then we can pose them to our panelists, and they can address your questions before we wrap up. But we've talked about all of the positive things that a tribunal secretary does or ideally should do, and the path that they should follow to getting there. I would love to know from each and every one of you, from your experience, has there been something that you've noted that tribunal secretaries are doing that you would recommend people avoid, or a gap that they should fill? And if so, what that is and how they should do so? We can start with Lady Justice, making our way round again. Lady Justice, are you still with us?
Yes, I'm still with you. Actually, I had changed location because of internet problems. Of course, I don't like the idea of tribunal secretaries sharing, information about what, the meetings, the deliberations that will, that will contribute to the awards, or, sharing information outside there. They should speak they shouldn't speak just, freely to people, even within the organization itself. They should avoid doing that, because that will really, really impact on the integrity of that tribunal, that particular tribunal. It can affect, them getting more work if parties get to learn that there are people there who speak about their deliberations and awards. So it's about confidentiality. Yes, thank you.
Olga, from you?
Oh, I think there's so many red lines that the tribunal secretary should really avoid, and most of them actually do, in particular those who are trained and certified as tribunal secretaries. But in addition to their confidentiality that Lady Justice mentioned, I would mention two other categories. Confidentiality would probably relate to the category of tribunal secretary engaging with the arbitral process itself. But for other two categories would be tribunal secretary's relationship with the tribunal and then with the parties. In terms of the secretary's relationship with the tribunal, I would think the red line would be, or something that I would not advise tribunal secretary do, would be for the secretary to challenge the tribunal's views on how the case should be resolved, amend the drafting, argue with the presiding arbitrator on what should be in the award, in particular when it comes to than dealing with various procedural recitations. Another point in that category would be for the Tribunal Secretary to avoid sua sponte, on its own volition, to reach out to the parties on behalf of the Tribunal. And I've observed that behavior, very unusual though, as it is, in 2 cases where the tribunals were quite upset by the Tribunal Secretary reaching out to the parties with various issues when the Tribunal did not actually instruct the Tribunal Secretary to do that. So that's the Tribunal category. On the parties category, there are so many red lines, such as, for example, engaging in any ex parte communications with the parties, or say, and that's what I've experienced myself, attempts of that as the Tribunal Secretary, where a party counsel would call you up on the phone and ask for substantive advice on how to frame, for example, an argument or something. So that would be an absolute red line. Or getting it into a very sort of close relationship with the parties counsel or the parties when you're acting currently as a Tribunal Secretary on the case where they are parties, such as going to dinners, accepting gifts, discussing the case, mentioning what the Tribunal is doing. So that would be an absolute no. There are many others, but I think these are the most flagrant.
Great. Saisen, perhaps your last thoughts before we go into the Q&A session?
To be honest, I don't have anything to add because Lady Justice and Olga already covered everything I wanted to say, and I think red lines also clearly stated in the HKIAC guidelines. So for those who are interested, please take a look.
Great. We have a bunch of questions in the chat, and perhaps I can just pose them at random. Somebody asks, has Saisen, have you encountered a situation where the tribunal decides it needs a tribunal secretary, but a party is opposed due to the additional costs? How have you dealt with that? Or how did the tribunal deal with that in that instance?
That's a really good question, because I did encounter this as a case manager. So the sole arbitrator wanted to appoint a tribunal secretary from HKIAC, and then they suggest this idea to the parties. One of the parties agreed, and the other party objected on the basis that they were concerned about the increase of the costs, which of course were unjustified. So if you look at our guidelines, also international practice, like, of course, if the tribunal appoints a tribunal secretary, they need to consult with the parties. But still, the tribunal has the final say on whether they need a tribunal secretary or not. And in that case, the sole arbitrator wrote to the parties explaining how appointing a tribunal secretary will save the cost. Because in that case, the sole arbitrator, their fee was calculated on the basis of the hourly rate. So I remember like their fee was like 4,000 Hong Kong dollar, which was about $500 US. And the tribunal secretary proposed by the sole arbitrator charged 700 Hong Kong dollar per hour, which was less than 100 USD. And then tribunal, basically the sole arbitrator explained to the party that I appointed a tribunal secretary, and this is how this will like help the party save the cost. And then the sole arbitrator finally appointed that person. Yeah.
Great. I think that was very clear. We have another question, and perhaps Olga, you can take a stab at this one. As a tribunal secretary, how do you handle parties who refuse to remit the arbitrator's fees? How would a tribunal secretary go about such a scenario?
I think that's sort of but beyond the tribunal secretary's mandate. in an administered institution, a case manager would typically monitor the deposits and would inform the tribunal whether the deposits are paid, if they're paid by both parties, or just basically the entire statement of account. And on that basis, the tribunal will then be able to, depending on the rules, either issue requests for additional deposits or requests for the claimant, for example, to pay the respondent's share or otherwise. In that context, the tribunal secretary would be able to draft the relevant correspondence from the tribunal to the parties. But typically, in an administered arbitration, that is something that the administering institution would do. That is all to say that the tribunal secretary is unlikely to have the power to discipline the parties in that regard beyond just conveying the requests for additional deposits. There are other mechanisms in various applicable arbitration rules to deal with the parties who refuse to pay the arbitrator's fees. For example, in the HKIAC rules, there's a provision saying that the award can be held back until after the required deposit is actually paid up. But that will also be handled usually by the institution itself. But also, I think the Singapore International Arbitration Center has very similar provisions. That brings me to one of the red lines, I think, that I mentioned earlier, where it would not be the tribunal secretary's role to on its own will to reach out to the parties and say, well, you haven't paid, and this is what I'm going to do. But I'm very happy to also defer to Sitsen, who I'm sure encounters these situations quite frequently.
Yeah, thanks. Aysen, do you have anything on that before I move to Lady Justice? A comment on that?
Yeah, I just want to add, add that HKIAC does have the rules that if the arbitrator's fees are not paid up, and we as institution HKIAC and also tribunal both have the right to exercise a lien of the world, and that's how we make sure that the tribunal's fees are paid.
Great. Lady Justice, we have a question here, and it predominantly centers around Africa. So I can't think of anybody better to answer that question. And it says, in Africa, what or where does one get certification as a tribunal secretary? It is quite a new aspect. There are rules or guidelines that bind the secretaries. How do we ensure that they do not violate the arbitral process? Your comments.
Actually, in Africa, we do not have any institutions that certify these secretaries. And I think the nearest is on the UK, the Chartered Institute of Arbitrators, UK perhaps. That's the one that can certify these secretaries after undergoing training. It's actually a very new area here in East Africa. Personally, I hadn't heard of the tribunal secretary until, I was asked to do the research on this for this webinar. So it's a very new area, but it's potential to employ so many lawyers. There are so many opportunities out there, and it's something perhaps our own, Chartered Institute in Kenya, the Kenya branch, should take up so that, they start training tribunal secretaries and certify them. Yes.
Yes, in fact, speaking of, we do have a Ciarb here training on tribunal secretaries. So again, if you've not registered, register. The link is on their LinkedIn page. But over and above that, just speaking from myself and my own experience, when I started out, I got my certification from ICC. And I do know that several other international arbitration centers do the exact same thing. So perhaps it's worth reaching out to some of these international institutions. Some of these courses are online and they're free, and you can do them from wherever you are, and it's really, really efficient. Are there any other questions on the platform? There's one other question. Perhaps, Saisen, you can address it. What is the difference between a tribunal secretary and a registrar?
So because in the context of HKIAC arbitration, we don't have the concept of registrar. I understand in some institutions they have a registrar. If I'm not mistaken, I guess at the CIAC, Singapore International Arbitration Center, they have a registrar, which similar. My understanding is that the registrar has a similar role as a Secretary General of HKIAC. Based on that understanding, so registrar is someone from Secretariat. And then tribunal secretary is someone who works for the arbitral tribunal, and that's a concept. I think it's established like the tribunal has its own sovereignty. It's like once the tribunal is constituted, of course, even if the arbitration is administered by an institution, the arbitral tribunal is independent from arbitration institution. So registrar is someone from institution, which may be administering institution or appointing authority. And the secretary in this context, of course, can mean several things. It means tribunal secretary, which primarily serves for the tribunal. If Olga can help me with that, because I guess you have some experience with PCA or CIAC.
Do I have a minute for that?
Yeah, you can chime in on that, and then we have one final question before we wrap up.
All right, very quickly then. Sita is quite right. I think the main difference between a registrar and the tribunal secretary is that the registrar would be somebody employed by the secretariat of the institution working on that case and with that particular tribunal, while the tribunal secretary would be specifically dedicated working for the tribunal. Now, it gets a little blurry where, for example, such as at the HKIAC, tribunal secretariat members can actually take up appointments as tribunal secretaries. So they're at the same time tribunal secretaries, but also case managers at the HKIAC. But they're in those cases, they're not called registrars. What I think where that distinction is very visible is with the Permanent Court of Arbitration in the PCA, where the International Bureau of the PCA, largely essentially the Secretariat, would serve as a registrar. They would essentially perform very similar functions, largely administrative case management functions, but also take on some of the tribunal secretary's role when serving the tribunals. Now, with the PCA, the fact that the registrar would act as such on a case doesn't exclude the fact that the tribunal may still appoint a tribunal secretary. For example, in the case that Lady Justice mentioned, it was the UKAS versus the UKAS shareholders versus the Russian Federation. The PCA in that case acted as a registrar with the entire team of legal counsel at the PCA working for the tribunal. And in addition to that, there was also a very experienced tribunal secretary who was at the time a partner, head of arbitration practice at Norton Rose. So that actually fueled some of the criticisms and gave some grounds for the Russian Federation to actually challenge the award on the basis that, well, if you already have the registrar as the secretariat, what would be the role of the tribunal secretary then? That must then be the very substantive role, delegating the decision-making powers to this tribunal secretary, largely being the fourth arbitrator. And that sort of brings us, but loops us into the discussion with which we actually started, on whether the concern of the fourth arbitrator is still valid. And I think I'll stop here.
Great. A final question, and perhaps Lady Justice can sign us off with this one. An audience member asks, is the role, I beg your pardon, is the role of a tribunal secretary limited to lawyers only, both internationally and in East Africa? What would your comment be?
I think it's not just lawyers who can work as tribunal secretaries, even other professions. We have architects who are arbitrators, we have surveyors who are arbitrators, engineers. So any of these professions can work as a tribunal secretary. Yeah, since we have those institutions, we have the ICE, we have, they do arbitral work. So similarly, the same professionals can work as secretaries. So they should really interest themselves in this area.
Right. Perfect. At least it's all encompassing and all accommodating. So that's all the time we have for this afternoon. I want to thank our esteemed panelists, Olga, Saisen, Honorable Lady Justice Henrietta. I'm so grateful to Ciarb and HKIAC for organizing this. As stated before, register for the Tribunal Secretary training and look out for more webinars. Thank you so much for your time, and we hope to engage with you soon. Goodbye.
Sorry,
Okay.
before everyone goes, I just want to share the link.
Okay.
Yes,
feel free, Saisen. You can put it on the Dropbox message below.
Yeah, just want to mention that for the Tribunal Secretary training program, and we are hosting with the Ciarb Kenya, and just like very quickly. So it's a 2.5-day program, and then you will have the opportunity to get hands-on experience through quiz and written assessment and interactive discussion networking opportunity. So here's an exclusive opportunity from for you, like the early bird rate has already ended on our website. For all webinar attendees today, we are offering the same early bird rate, which is $250 and 330,000 Kenyan shilling, and this special rate expires on 30 April. So you can scan the QR code to register. So it's still early bird rate, and we will hope to see everyone in Nairobi next month.
Thank you so much for that, Saisen. Thank you everyone once again for joining us. Register and see you next month.